Thank you very much, dear Yifeng. Thank you, dear colleagues from Beda, Peking University Law School, especially from the International Law Department. It's my great pleasure to talk to you today, but of course, it's my great regret that I cannot be in person with you in Beijing, but I hope that from next year on, this will again be possible because I would like to see you all again in person. You will note on the slide that I put a new Chinese name on the slide, which was designed and selected by Dr. Fan Yuan for me. I would like to start with a joint statement by the foreign ministers of China and Russia on certain aspects of global governance in modern conditions, which was issued in March. I quote the joint statement. The ongoing coronavirus pandemic has served as a catalyst for a change in the world order and provoked even greater imbalances in the global governance system. In this context, we call on the international community to build up cooperation, to contribute to the establishment of a fairer, more democratic and rational multipolar world order. Of course, this is only a political statement. It's not a legal document. And it is, of course, also a strategic text. Maybe it is cheap talk. Nevertheless, I suggest to take this seriously. So what does fairer and more democratic and rational mean? In 2019, on the eve of the G20 summit, Russian President Vladimir Putin had said that liberalism is obsolete. So has the constitutionalist trinity of rule of law, human rights, and democracy that was also proclaimed by the United Nations General Assembly to be relevant for the international level, has this so-called trinity been replaced by the ideals of populist sovereignty, security, and prosperity? The topic of my lecture today is to analyze what's left of global constitutionalism. That was a paradigm that was elaborated in the first decade of the millennium in response to the extraordinary evolution of both international law and the evolution of national constitutional law in many states after the demise of the socialist bloc, symbolized by the fall of the Berlin Wall in 1989. So is this paradigm, or one could say ideology, of global constitutionalism only marching along in a zombie mode? In this talk, I will argue that global constitutionalism can avoid marching straight ahead on the path mapped out long ago, even as the lifeblood drains out of the enterprise, as it was said about human rights by Philip Alston. But Alston called for a revision of the human rights theory and practice. Same for global constitutionalism. It can avoid becoming a zombie only if it critically reviews its colonial legacy, if it overcomes Eurocentrism, and most of all, if it builds up a fourth pillar, transboundary solidarity and social rights. And such a revamping is indispensable in order to adapt the paradigm of global constitutionalism to new material conditions and to a new ideational climate. The change of material circumstances, which I perceive, consists in a power shift away from the Western world towards Asia. States that have traditionally applied a top-down governance style and which lack a deeply rooted rule of law and democratic tradition are on the rise. And besides, even traditional democracies are eroding from the inside, as we saw, for example, with the violence against the US-American Senate in January this year. Second, the fruits of globalization are unevenly distributed. The wealth trickle-down effects through trade liberalization and foreign investments have not reached everyone, not the most poor and abject. Roughly speaking, material inequality of wealth and income is rising in different degrees, both inside countries and across countries. Also, the poorer classes in the wealthy states have not benefited much from globalization, but rather feel threatened by globalization. These facts, or these new impressions and interpretations of facts, have caused a groundswell of discontent with globalization, as the former executive director of the International Monetary Fund, Christine Lagarde, put it already in 2016. A third factor is digitalization. The positive side of digitalization is more access to information and also the facilitation of civil protest and scandalization processes, for example, against human rights abuses. The digital information also renders more visible material inequalities in the world, and this leads to more dissatisfaction. And the digital media may also create opinion bubbles, which in turn fuel conspiracy theories. This brings me to the changes in the ideational climate, which partly responds to the material changes. The buzzwords here are post-colonialism, populism, post-humanism, and post-liberalism. Embedded in this overall intellectual climate are more specifically attitudes towards international law. First, there is disillusionment with international law. The insight is spreading that international law might have been expanded on paper without sufficient attention to its implementation. So we have the charge of ineffectiveness of international law. But for others, international law might even be too effective because they are dissatisfied with its substance. International law has a tainted origin with its European and colonial legacy. And linked to this heritage is arguably a one-sided content of international law. It favors Western states and their economic interests. This skepticism and even backlash against international law inevitably involves its deconstitutionalization, at least partly. At this point, I must explain what I understand by constitutionalization and by global constitutionalism. Global constitutionalism had its heydays in the first decade of this millennium. What did it mean then? And what can it mean today in the current constellation? Global constitutionalism is an ism, and this involves both a positive analysis and a normative agenda. The positive analysis, the description, lies in the reading and reconstructing some features and functions of international law in its interplay with domestic law, as forming constitutional bits and pieces and as reflecting constitutionalist principles. And these principles are the rule of law, human rights, and democracy, the constitutionalist trinity that I mentioned before. Importantly, constitutionalization, the process of bringing political power under these constitutionalist principles, is a multi-level phenomenon. It concerns both international institutions and states. Global constitutionalism also pursues a normative agenda. Constitutionalist principles are employed as a benchmark for the critique of international law as it stands. And the vision is that the international legal order, its institutions and procedures can and should be interpreted and progressively developed in the direction of greater respect for the constitutionalist trinity. The question of today is, what, if anything, is left of these constitutionalist features of international law? Where and how does a deconstitutionalization take place? we witness active attacks and erosions of core global constitutionalist principles. I will go along principle by principle of the Trinity. A first trend is the erosion of the international rule of law. We see skepticism against and withdrawal from the so-called third-party dispute settlement mechanisms, courts and tribunals. We also see non-compliance with judgments of international courts, notably the European Court of Human Rights. Also, the inter-American human rights system suffers from a perennial funding crisis and faces rising domestic courts resistance. In the South Chinese Sea arbitration, China did not recognize the jurisdiction of the arbitral tribunal and does not recognize the award of 2016. Next, there is the critique against investor-state arbitration system as manifesting the neoliberalism of international law. Second, a broad gamut of critiques against international human rights is unfolding. Notably, since the 1990s, the doctrines of international human rights have been more and more refined, so that now human rights permeate the entire field of international law. Also, new human rights are constantly being propagated, such as the right to the city or the right to erasure on the internet, to name only a few. Critiques speak of a rights inflation, a rights proliferation, and of rights overreach. Human rights now suffer from a broad and deepened ideational critique, which goes far beyond the classic cultural relativist objection against human rights as a crusade of the West against the rest. The renewed theoretical critique against human rights now spans all ideational camps, from neo-Marxism over populism up to neoliberalism and conservative originalism. For example, a Catholic-led US Presidential Commission on Unalienable Rights in 2020 released a report in which the Commission proposed to cut back human rights to their roots. On the other side of the ideological spectrum, neo-Marxists consider rights only as the superstructure to protect the ruling class's property. To conclude, there is an unholy alliance against human rights. Next, the attack on the International Criminal Court, notably by African states, is also important for global constitutionalism. After all, the International Criminal Court, which seeks to terminate impunity for individual perpetrators of international crimes, this court could be said to be a capstone of what has been called the humanization of international law. The fourth strand of deconstitutionalization concerns the third Trinitarian principle, democracy. Populists claim to speak for the people and point to democratic deficits of international law. These shortcomings of international law are real. The democratic legitimacy gap in international lawmaking is being recognized and has given rise to novel practices that seek to fill that gap, ranging from involvement of national parliaments, civil society organizations, to more transparency. All this is well known. However, is the expectation of democratic international treaty making still adequate? Is democracy, more generally speaking, the correct benchmark? We witness an erosion of democratic governments worldwide, and this has consequences for the quantity and substance of international law and its institutions. We see new alternative organizations whose institutional design is heavily influenced by non-Western preferences. For example, the Asian Infrastructure Investment Bank, founded in 2016, and the BRICS Development Bank, founded in 2014, These two organizations display less transparency and allow for less civil society participation and less access to remedies than the World Bank. They are, therefore, one could say, less accountable to individuals. These findings underscore that the two levels of governance, the domestic level and the international level, cannot be separated. As I said at the beginning, global constitutionalization and the potential deconstitutionalization is inevitably a multi-level phenomenon. So where do we stand now? On the level of norms, we still see constitutional fragments in a pluralist legal space. These islands of the constitutional, as Gunther Teubner put it, are pretty resilient. With regard to the rule of law and judicial dispute settlement, the International Court of Justice continues to receive not many cases, but highly important ones. I only wish to recall the pending affair over the relocation of the United States Embassy to Jerusalem and the genocide case between the Gambia and Myanmar. In the field of investment protection, the European Union's Commission pursues the plan of a multilateral investment court system, and this system seeks to offer better institutional guarantees of judicial independence, more legal certainty, and improved legality through an appellate court system. The EU investment treaties since 2016 with Canada, Singapore, Vietnam, and Mexico all include such an investor court system as opposed to a reference to arbitral tribunals. With regard to human rights, people all over the world, from Venezuela over Nigeria, Bangladesh, and Hong Kong, seem to believe in rights. They believe in the magic wand, as critical race scholar Patricia Williams in a seminal book of 1992 called Rights. The protesters worldwide in 2019, which was a year that was called the Year of Peaceful Protests, confirm that obviously people on the ground hope for a practical benefit of rights, however shaky the theory of human rights might be. And with regard to the democratic principle and practice, some international organizations have introduced reforms in the direction of more civil society engagement. A prominent example is the radical reform of the so-called civil society mechanism in the Committee on Food Security in the Food and Agriculture Organization, a reform of 2010, which responded to the world food price crisis of 2007 and 2008. A final island of constitutionalism in international organizations are the persisting initiatives to tie the United Nations Security Council, more specifically the P5, to legal and one could say to constitutional standards. France, Mexico, and other states and civil society actors are continuing to push for the responsibility not to veto. The quest is that the P5 commit themselves not to veto military action to prevent and terminate mass atrocities such in Syria and Myanmar. These initiatives have led to the signature of a political declaration on suspension of veto powers in cases of mass atrocity by meanwhile more than 100 states. But 2 or maybe 3 of the P5, China, Russia, and maybe also the United States, firmly resist curtailing their veto power. These constitutionalist bits and pieces have to be assessed against the facts of our globalized life world. Although the hyperglobalization of the 1990s and the early millennium might have meanwhile been replaced by slowbalization, as The Economist put it, it is very unlikely that globalization will be reversed. The COVID pandemic is just one illustration of our interconnectedness, resulting from the mobility of capital and persons, transnational supply chains, and the rise of corporate power. And this ongoing condition will continue to throw up new challenges for constitutional law. However, we cannot return to the business of global constitutionalism as usual around the turn of the millennium, whatever this is assumed to have been. We need to renew global constitutionalism or to discard it. A first point is that most of the frames of the discipline of global constitutionalism have been the beneficiaries and vehicles of a colonialist legacy. And we need a critical review of that legacy. In other words, we need to develop a post-colonial sensitivity and a self-reflection on Eurocentrism. For example, even the COVID crisis manifests some Western arrogance, because Western states have refused to learn from several Asian countries which have done extremely well in combating COVID-19, not necessarily by violating constitutional principles if you think of democratic Taiwan. Next, cultural pluralism is important. It is a value in itself. However, historical experience shows the frequently pretextual character of the invocation of culture, which cloaks other conflicts. For example, the European Union's animal welfare mainstreaming clause in the Treaty on the Functioning of the European Union contains a reserve for the cultural traditions in the various member states. This reserve, or counter-obligation, was included upon lobbying by Spain. A Spanish statute then legally defined bullfighting as part of the cultural heritage of Spain, so that it fits exactly under the EU exception. This invocation of culture has almost nothing to do with animals. It is rather about the political conflict between Castilian Spain and Catalonia, a region which has long prohibited bullfighting. Second, cultures do not unfold inevitably, as if according to a genetically defined pattern. Habits and traditions are not per se worth protecting simply because we call them culture. There was a culture of binding women's feet, and there still is a culture of mutilating women's genitals, and there is a culture of eating animals. But a collection of stupidities and cruelties is not worth protecting as such, as little as the prohibition for women to drive a car and the practice of marrying children at the age of 10 is worth upholding. In order to find out whether women want to drive a car or to be married at the age of 10 to a 30-plus-year-old man, we must ask the women and not their husbands. To conclude, cultural diversity is no blank check for abuse. Finally, the probably most important flaw of global constitutionalism has been its neoliberal tilt. The constitutionalism of the 1990s entailed not only a rolling back of possible restrictions on capitalist property rights, but it contained a rolling forward of a new international juridical framework that systematically privileges the rights of capital on a world scale. There has been a mismatch between global markets on which global capital moves, coupled with global rules that secure and protect capital, the market enabling rules of the WTO, World Trade Organization, and investment protection agreements, and these regimes are accompanied by robust dispute settlement mechanisms. On the other hand, the market constraining regimes, which would realize a social protection and social security of the weaker market participants, has been confined to the national level. And this mismatch has assured that the lower level, the national policies designed to redistribute wealth and correct market failures, they remain constrained by the outmigration of firms. And the real or perceived policy competition, which makes national governments hesitant to levy the taxes they need in order to fund social programs and to raise distributive taxes, this competition functions as an effective factual constraint on the domestic social policies as well. The mismatch between the globalization of the economic regulation and the domestic confinement of the social regulation can, as I said before, not be remedied by reshoring the industries. Bringing industries back home and turning back economic globalization is no real option. The next indispensable step for rescuing global constitutionalism is to stop hypocrisy and double standards. The Chinese-Russian Declaration on International Law of 2021 that I quoted at the beginning makes this important point. I quote the resolution or declaration. It is time to stop attaching a political agenda to the topic of human rights and abandon the practice of using it as a pretext for interfering in the internal affairs of other states and applying double standards. End of quote of the declaration. The condemnation of double standards is very valuable. For example, it is not convincing to condemn the Chinese influence in the WHO and the World Health Organization, while other international organizations are dominated by Western states, such as the World Bank, whose president is always a US citizen, and the International Monetary Fund, whose managing executive director is always a European by unofficial custom in those institutions. The reproach of hypocrisy and double standards must be taken seriously because equal treatment is a core principle of constitutionalism and of the rule of law. However, three important points put the reproach of double standards into perspective. First, we must not buy into a pretextual invocation of ostensible double standards. For example, in a press release of March by the Chinese Foreign Ministry spokesperson, the Foreign Ministry reacted to the critique of Western states against the situation in Xinjiang as follows. I quote the press release. It must be pointed out that these countries who proclaim themselves to be judges of human rights and are keen to lecture others have an ignoble record on human rights. They are not in the position to criticize China, much less to shift blames to China for what they have committed. As early as in the beginning of the 20th century, German colonists slaughtered indigenous Namibian tribes. Between 1904 and 1908, German military killed over 100,000 indigenous people, including 3/4 of the Herero people and over half of the Nama people. End of the quote of the Chinese press release. It is true that Germany committed atrocious crimes, which from today's perspective must be qualified as genocide. Actually, Germany has only some days ago, after much pressure and also after litigation, acknowledged this and has extended an official apology. Germany has also only now established a fund which will pay 100 million, so 1 billion euro to the Nama and Herero peoples. But that's not the point here. My point is that when we analyze these two cases in detail, we see that these are not similar cases, but that they display important and legally relevant differences. In 1905, human rights were not yet acknowledged by law. There was no concept of crimes against humanity and no legal concept of genocide. Colonialism was not yet condemned as unlawful. This is relevant for the legal assessment. To treat these situations as similar in law is a false equivalent. Rather, it is appropriate to treat these situations differently. A second point, the proper remedy against hypocrisy is not stopping to criticize abhorrent abuses elsewhere, but rather to terminate one's own abuses too. So double standards should be terminated by leveling up and not by leveling down. Thirdly, the reproach of hypocrisy and undue interference does not necessarily end the matter. The implication of this reproach is that the West should leave the rest alone until the West has cleaned up its house first. But I now quote the Korean US-American political scientist Claire Kim, unjust disadvantages of the global South in one sphere does not earn them unjust advantages in another. Having endured racism and colonialism, subjects deserve justice and reparation from their oppressors, but they do not deserve to dominate women, animals, and nature. End of quote. To give an example, it is true that Herero and Nama morally and maybe also legally deserve reparation from Germany. It is also true that China, a victim of cannon boat policy and unequal treaties, deserves justice. But this does not give anybody a license to oppress minorities. On the contrary, under the United Nations Genocide Convention and under customary international law, China and actually all other states as well are obliged to prevent genocide and to prevent crimes against humanity. The legal obligation to cooperate to bring to an end serious violations of peremptory norms of international law also arises under the International Law Commission's articles on state responsibility, which to some extent codify customary law. This means, for example, for Western states, including Germany, there is a legal obligation to inquire and ask for information. As soon as, and now I quote the International Court of Justice, with regard to genocide, as soon as a state learns of and should normally have learned of the existence of a serious risk that genocide will be committed, end of quote, of the ICJ in its 2007 judgment on the genocide in Bosnia, as soon as a state normally should have learned of the existence of a serious risk, it has an obligation to do something. I'm now not speaking of sanctions, but of a quest for information and transparency as procedural obligations. So, what is then a promising strategy in political terms that we, as international legal scholars, could intellectually prepare and comment on critically? We need to tackle the global social questions in order to mitigate the neoliberal tilt of global constitutionalism. A more social global constitutionalism would comprise the following elements, which I put on the slide. First, we need to strengthen investor obligations, and this is already done in some bilateral investment treaties. One example is the treaty between the Kingdom of Morocco and Nigeria, an agreement of 2016, which is, however, not yet in force. Second, we need to contain the unleashed corporate power. The current legal trend goes in the direction of indirect human rights obligations of business through the state's obligation to protect. And this is proposed in the United Nations Human Rights Council Working Group draft on a legally binding instrument on business and human rights. This is, I think, welcome. And this draft again shows the need to intertwine international law with the domestic law in order to rein in business. Third, internationally codified social rights need to be operationalized. Until recently, the practical significance of international social rights was very limited. Since around the turn of the millennium, domestic courts, notably in India, South Africa, and Portugal, and also international and regional monitoring bodies have begun to adjudicate on social rights. And this new body of case law is revolutionary for two reasons. First, it transforms social rights from rather programmatic provisions into operational entitlements. Secondly, this case law has the potential to transnationalize the rights because the courts and committees enter into a judicial dialogue and are likely to align the guarantees to each other. On the universal level, for example, the first optional protocol to the International Covenant on Economic, Social, and Cultural Rights now allows, since 2013, individual communications about violations of the social covenant rights under the ICCSR. And the ongoing pandemic is contributing to the strengthening of social rights. It leads agencies and courts to apply social rights, the social right to health notably, and this has consequences for building up health infrastructure and policies as a matter of a legal obligation arising out of the right to health. The fourth imperative is to operationalize the international legal principle of solidarity. I submit that the moral principle of transboundary solidarity has been in a very selective and patchy way acquiring now a thicker legal meaning, especially during the pandemic. In parallel to a whole range of nationalist reflexes and actions which we see, notably vaccine nationalism, pandemic-related legal pronouncements have invoked global solidarity. The United Nations General Assembly resolutions on COVID appeal to solidarity, and the World Health Assembly also appeals to solidarity. And this new talk, although it is to some extent cheap talk on global solidarity, might contribute to the sedimentation of solidarity as an emerging structural principle of international law, as it had already been qualified before the pandemic, for example, by my predecessor, Rüdiger Wolfram. Fifth, the nexus between the rule of law and development needs to be acknowledged. This nexus has been brought to the fore by the Agenda 2030. The rule of law goal in Agenda 2030 had been controversial. This was one of the hottest topics in the adoption process leading to Agenda 2030. The sub-goal 16.3 of Agenda 2030 is, I quote, to promote the rule of law at the national and international levels and ensure equal access to justice for all, end of quote. And my proposal is that global constitutionalism should move further towards embracing the social dimension. However, this proposal faces objections and caveats, and I mentioned three caveats. First, currently and in the foreseeable future, the making and enforcement of international rules remains decentralized. It remains in the hands of states. There is no international center, and it is hard to see how such a system could ever manage money flows and contribute to redistributing actually money. So the social constitution I'm asking for will not be able to distribute money or to raise taxes. A second objection might be that the thickening of international constitutional law in the direction of a social dimension is totally utopian. It might seem utopian given the current backlash that I mentioned, a backlash even in the traditional areas of international law, such as use of force, stability of boundaries, and so on. But my response is that these symbolic topics, the symbolic topics of sovereignty and non-intervention, are merely verbally in language detached from the economic interdependence in the political discussion. Because in reality, and this is an important point, the populist rhetorics insisting on state sovereignty, America first and so on, insisting on territorial integrity and on national identity, this rhetoric is a typical reaction to the anxiety of governments and the anxiety of the voters. And this anxiety is caused, at least in part, by economic globalization and interdependence. And that means that the social fallouts of globalization must be addressed exactly also in order to reinvigorate the respect for the traditional international law principles. A third objection is that what I proposed is a purely incremental and reformist approach. It lacks a revolutionary impetus. My approach does not attack the basic structures of capitalism, and it does not call into question the existing international economic order as a whole. In contrast, a revolutionary stance would say that deprivation of large groups of people is planned and that it is perpetuated by the powerful designers and by the exploiters of international law, and that these exploiters are politicians in the affluent states in collusion or captured by global capital. So this would be the revolutionary critique. And I concede to this critique that my reformist, more social constitutionalism carries a risk of deflecting from the root causes of social misery. However, I think we should also remember that both international legal experiments on the governance of the global social question, which were at the extreme end of both ends of the political spectrum, that these historic experiences have not fared well. And I'm speaking here of the new international economic order of the 1970s, which was basically human rights free. And I'm speaking of the neoliberalism of the 1990s. And both experiments have not contributed much to global social justice. And against this historical experience, a reform strategy with international social rights, notably the right not to live in abject poverty, as its centerpiece is worth trying, I think. My conclusion is that the traditional trinity of global constitutionalism can and should be extended to cover a fourth limb, a social limb. And I think that it is a responsibility of international legal scholars to come up with such an idea, because this is the job of scholars. To conclude with the French author Victor Hugo, who is of course well known, not the least because of his condemnation of the criminal Anglo-French destruction of the old summer palace in the north of Beijing in his book Expédition de Chine. Victor Hugo, in a different book, wrote, "One resists the invasion of armies, one does not resist the invasion of ideas." 谢谢。